we plan this to have a split webinar with roughly 15 or 20 minutes from me and the same from Claire Roake. With questions, we should easily be wrapped up by 11:40. I would also, by way of housekeeping, just like to let you know that you're all on mute. But if you have any questions, comments, suggestions, especially for future talks, please do pop them in the Q&A function. We'll do our best to answer them at the end. And we assure you that we won't identify you when reading out the comments and questions at the end, so don't be shy. If there are a lot, then we will continue the conversation individually and email privately afterwards to avoid going over the time too much. So today, I will begin with a roundup of the reasons for the challenges IFAs and their insurers have faced over the past few years. Claire will talk about two important cases, Adams and Carey pensions and the Berkeley Burke case, and the impact of those on the SIP industry. I will then conclude by talking about future risks and generally whether we're coming out of the woods yet. But first, I'd like to do a poll. So please follow in due course the on-screen instructions. We're getting lots of results. Results. I will share the results. Interesting. The PI market for IFAs is harder than it has been for over 10 years. And in preparation for this talk, I looked back on my notes from 2017. And at that point, there were so many more insurers. Things have squeezed a lot since then. And it may not come as much consolation, but I do feel rather sorry for the poor IFAs, as I don't think it's their fault, as the next slide will demonstrate. Oh. Regulatory change, the factors which increase risk. I wouldn't be overstating it if I said that the 2015 pension freedoms are the biggest changes in pensions industry has faced in a century. And of course, it's going to have a huge impact. As for the teeth, some would say that the FCA comes down hard after the event, which seems particularly harsh when it isn't clamping down on mis-selling as it should. It allows products which arguably should be banned to be sold for some years, giving guidance and statements but no active intervention. The FCA fined Sesame Bank Hall £6 million for its role in key data, and this is a good example of that, like settlement bonds should and could arguably have been banned. We thought that fine was bad at the time, but in December 2019, the fines again hit record levels. According to an FT article that I read in research for this talk, fines hit £391.8 million in 2019, with a few super fines exceeding £10 million. Fines might not be covered, but obviously the FCA investigations and defence costs are. Poor standards. I think no. I think it would be grossly unfair on the IFAs to say they haven't learnt anything since the pension scandals of the 1980s and 1990s. When I started out my career, I dealt with those claims, and if we fast forward 20 plus years, I can definitely say that the IFAs who survived are a radically different breed from those who thrived back then. Standards have also shot up hugely again since the RDR of 2012. IFAs look like every other professional now. They're properly trained professional financial advisors with codes of ethics and transparency and charging structures, continuing professional development, etc. In my view, any IFA still in business now has never been in better shape. Litigation culture, easy access, dodgy decisions, the next 3 points are all linked. Yes, we have a litigation culture. We have claims management companies behaving like ambulance chasers, actively cold calling investors, offering so-called free pensions reviews to help you claim. On top of that, you have all kinds of new funding arrangements which make access to justice that bit easier. Then on top of that, you have the FOS. Financial Ombudsman Service was set up by statute to decide what was originally intended to be small claims and take them out of the court, stop the courts getting clogged up. What's happened instead is that the number of claims has shot through the roof. There's no cost risk to claimants, so they may as well have a pop. Now thousands of claims are handled by what is essentially, in my view, a sort of quick and dirty tribunal, with unqualified individuals doing what they think is fair and reasonable, sometimes regardless of the law, and that might differ from one day to the next and between ombudsmen. And all this means that the IFAs have no idea where they stand. On top of that, the FOS's cap has grown to £350,000. In my view, the FOS is now basically trespassing on work that falls within the realm of High Court litigation. Stupid and greedy investors. Well, some of you might think that that's a bit of a harsh bullet point, but I think it's fair to say that with interest rates at record low levels, investors have got a bit bored and are more tempted to make a fast buck in an unusual way. Even teak farms and storage pods and Caribbean holiday apartments start looking appealing. I'll talk a bit about the rise of the SIP later on that point. Economic downturn. The final point is relevant to future claims. Essentially, investors are not going to claim if their pot has grown. I think it was Warren Buffett who said that it's only when the tide goes out that you discover who's been swimming naked. And of all of the factors above, the one that drives claims above all else is the economy, and that's why it's got 2 ticks. Problem with pensions. Now, this slide is just a brief reminder on what the changes were. It's a talk in itself and one most of you probably had a few years ago, so I don't propose to read it all out. I do, however, want to highlight that these changes have led to over £100 billion worth of assets being drawn down to date. The key risk areas are the unsuitable defined benefit transfers. The most serious disquiet centres on the British Steel pension scheme, where thousands of people transferred out. Hundreds ended up in poor investments, and the FCA has warned that the damage from such bad practice could be £20 billion within 5 years. Aside from the British Steel pension scheme, the FCA simply says advisors should start from the position that a transfer is not suitable. It's deeply concerning and disappointing to see that transfers are still being recommended at the levels we have seen. And of course, it's assessed the suitability of advice and says that unsuitable advice is still too high. Last year, the end of 2019, Financial Conduct Authority warned that 2 in 3 savers were being told to transfer their pension pots out of the defined benefit schemes against their best interest. 2 in 3. If you're a saver, then that's an alarming statistic. But if you're an insurer of IFAs, that is a terrifying statistic. On top of that, there's also the issue that those with defined contribution plans have been able to access their pension pots. The point is that everyone has choice. And the marvellous thing about it for the government is that the investors pay tax as they take their money out. So the motive for making all those sweeping changes is bringing that extra tax to the Chancellor. Problem with SIPs. As I said in the last slide, there's been a huge surge in the number of SIPs. SIPs is an acronym meaning self-invested personal pension plans, DIY pensions. SIPs entered the mainstream in the wake of the 2015 pension freedoms as a wrapper, a vehicle in which to give people more control of their retirement savings. DIY investing platforms and SIP providers offer a range of online SIPs to investors who can buy and sell investments from their computer or even their mobile phone, monitor their portfolio. But pensions are complex. Wouldn't it be lovely to get some good advice before doing this? But not only is it difficult to come by, but investors don't want to pay for it. The Financial Advice Markets Review revealed in its report that 72% of people are not willing to pay more than £100 for advice, and over 85% are unwilling to pay more than £200. And it's not all one way. 69% of advisors have turned clients away in the last years, have not considered them to be wealthy enough. Despite consolidation in recent years, your average IFA practice still has fewer than 5 staff, profit margins under 5%. So when Mr. and Mrs. Bloggs walk into their office to say they want to cash in their pensions and buy a second-hand Ferrari with part of it, or some storage pods, or a part share of a luxury Caribbean hotel chain, you can see why the IFA wants to run a mile. This means that Mr. and Mrs. Blogg go off to a rogue, unqualified, unregulated salesman and do it through a self-invested personal pension, or a SIP, having received no advice whatsoever. Now, I'm making Mr. and Mrs. Blogg sound stupid, and they're not necessarily. Fraudsters operating in this area are very good at sounding both convincing and urgent. Almost 2/3 of people surveyed by the FCA said they would trust someone who offered pension advice out of the blue, and yet that is one of the key red flags that an offer's dodgy. And interestingly, the research showed that people with degrees are 40% more likely to accept a free pension review from a company they've not previously dealt with, 21% more likely to accept an offer of early access to their pension pots. The biggest problem for IFAs wanting to give advice on DB transfers is finding available PI cover, which means it's being done by unqualified people or being done without advice. And that means claims are being brought against the last man standing with PI insurance, even if it's only the mere SIP provider. Claire is now going to talk about 2 cases involving SIP providers, and I'll be back later for a little bit of crystal ball gazing. Over to Claire.
Thank you, Virginia. So, as has just said, I'm going to consider the decisions in Berkeley Burke and the Financial Ombudsman Service from 2018 and Adams and Carey pensions from this year. I'm going to quickly run through the facts and judgments in each of those cases, and then consider the implications for the SIP industry and their insurers. Now, in general terms, both of these decisions arise from investments in less conventional high-risk products that were held in SIPs. Given the claims that subsequently arose, needless to say, the investments failed, and the investors sought a means to recover their lost pensions. Now, sadly, over the past 5 years or so, this has been a common story, and it's given rise to a large number of complaints, particularly to the Financial Ombudsman Service, or FOS. And at least before the 2 decisions that I'm going to discuss, there was a lack of clarity as to the duties on a SIP trustee or administrator where high-risk investments are involved. So, looking first of all at Berkeley Burke and the FOS, so this concerned a complaint by Mr. Charlton. So in 2011, following discussions with an unregulated introducer, Mr. Charlton decided he wanted to transfer his personal pension to invest in a green oil scheme in Cambodia. The investment was held in a SIP administered by Berkeley Burke. Berkeley Burke acted on an execution-only basis. Berkeley Burke wasn't authorised to provide investment advice, and it made it clear that Mr. Charlton would need to seek that or any advice he wanted elsewhere. Following a serious fraud office investigation, it was found that the scheme was a scam. The company selling the investment didn't even own any land in Cambodia. And Mr. Charlton and the others who had invested lost their pensions. Mr. Charlton complained to Berkeley Burke and then to the FOS and sought reimbursement of the sums he had lost. Now, the FOS found against Berkeley Burke on the basis that it was fair and reasonable to have expected it to have undertaken due diligence on the investment. Berkeley Burke had not done so, other than to ensure that the investment was compliant with HMRC rules. The FOS also found that had Berkeley Burke carried out due diligence, it would have refused to accept the investment into a SIP, as it would have appreciated that the investment might not be secure or that it might be fraudulent. And in reaching those conclusions, the Ombudsman placed reliance on what it considered to be good industry practice at the relevant time. Now, Berkeley Burke sought judicial review of the FOS's decision. And as the challenge was by way of judicial review, the court wasn't seeking to retry the case, but to determine whether the FOS's decision was lawfully reached. Now, Berkeley Burke argued that the FOS had erred in law. As first of all, it had created a new and unexpected duty to undertake due diligence on underlying SIP investments. Second, It was argued that for execution-only business, the rules required Berkeley Burke to execute the transaction on instruction from Mr. Charlton. So, i.e., Berkeley Burke had no option but to follow Mr. Charlton's instructions to invest. And it was argued that a duty requiring extensive investigation into the underlying investment conflicted with Berkeley Burke's obligation to act on the client's instructions. And finally, it was argued that the FOS's decision conflicted with previous decisions of the Pensions Ombudsman on similar facts. Now, in short, the court rejected all of those arguments and found for the FOS on all counts. And it was significant that Section 228 of FUSMA requires that the Ombudsman determines a complaint by reference to what, in the Ombudsman's opinion, is fair and reasonable in the circumstances of the case. So the test is very subjective, and there's a wide latitude within which the Ombudsman can operate. He can, for example, depart from the law if justified and explained. And the court did not accept that the Ombudsman was creating a new rule regarding the due diligence required before accepting a SIP and accepting an investment into a SIP. The Ombudsman's approach was simply to identify the relevant rules and principles and to decide how they should apply in the context of the particular facts. And it was significant that the Ombudsman reached its decision on the basis of what he found was good industry practice. Similarly, the court did not accept that an execution-only relationship meant that the SIP operator was obliged to follow the client's instructions. It simply could not be right that the SIP operator had to act regardless. And finally, it didn't matter that the Pensions Ombudsman had reached different conclusions in similar cases. The Pensions and Financial Ombudsmans act under different regulatory regimes and reach decisions on different bases. Now, the court's decision, sorry, I missed a slide, decision in the Berkeley Burke case was a blow to the SIP industry. It suggests that SIP operators can find themselves liable even where they did not undertake sufficient due diligence in relation to the underlying investments placed into their SIPs. And that's in spite of SIP operators generally having no authorization to offer financial advice and making it clear that they're acting on an execution-only basis. Now, whilst it was the FOS's finding that carrying out wide due diligence on underlying SIP investments was good practice, certainly my experience of dealing with this type of claim suggests that it was not common practice for such due diligence to be undertaken. So the judgment therefore seemed to leave SIP operators and their insurers exposed. Now, following the Berkeley Burke decision, the SIP industry hung its hopes on the other then impending judgment in Adams and Carey pensions. Now, the hearing in Adams and Carey pensions took place in March 2018. It wasn't, however, until May this year the judgment was handed down, so some 2 years later. Now, Mr. Adams invested in Store First, which was an investment in storage pods which were intended to generate an income when they were rented out. Now, it will come as no surprise that it wasn't, as though Store First was a real investment rather than a scam, it was not a good investment. The Store First investment was held in a SIP provided and administered by Carey Pensions. Mr. Adams was introduced to Carey by CLP Brokers, an unregulated introducer. Now, Carey set up the SIP for Mr. Adams on an execution-only basis, and it made it clear that that was the basis on which it was acting. Now, in the claim, Mr. Adams alleged, first of all, breach of the regulatory regime, which he said rendered the SIP unenforceable under Section 27 of FUSMA. Second, it was alleged that Carey had failed to act honestly, fairly and professionally in accordance with Mr. Adams' best interests. And third, that Mr. Adams pointed to negligent investment advice by CLP, the unregulated introducer, for which he said Carey were liable as a result of joint venture, common design or agreed common business model. Now, in reaching judgment, the court noted that from supervisory visits, the FCA had been aware that Carey was using unregulated introducers, and it was happy with the approach that Carey had adopted and the due diligence it had completed. Carey's due diligence, just as Berkeley Burke's, had focused on whether the investment was suitable to be held in a SIP from an HMRC rules perspective. It did not extend to the suitability or appropriateness generally of the relevant investment. Another significant feature according to the court was the contract between Carey and CLP. The contract put clear limits on CLP's role and also on that of Carey. Significantly, CLP was not permitted to advise clients. Similarly, documents issued to investors made clear that Carey was acting on an execution-only basis and would not provide investment advice. It was also made clear that the investment decisions and obtaining relevant advice was the responsibility of the investor, so in this case, Mr. Adams. An important aspect of the evidence heard by the court was Mr. Adams' admission that he was aware that Starfrost was a high-risk investment. Mr. Adams also admitted that it would have made no difference to his decision to invest had Carey warned him of the risks. He believed that CLP had advised him on the investment and he was keen to receive the promised £4,000 inducement for investing. Now, I'm just going to look briefly at the specific arguments that Mr. Adams raised. The first of all was in relation to section 27 of FUSMA, which is on the screen. But basically that renders unenforceable an agreement to carry out a regulated activity where that agreement has come about as a result of the unauthorised actions of a third party. So in this case, CLP. And Mr. Adams alleged that CLP was undertaking unauthorised regulated activities by advising and arranging investments in Store First, and that those activities rendered the SIPP unenforceable. The court did not accept that and found that there was insufficient causal link between CLP's unauthorised advice on the underlying investment and the SIPP. CLP's advice did not necessarily result in a SIPP transaction. There were further steps that were necessary to establish the SIPP, and they were not under CLP's power to effect or direct. So Mr. Adams' claim under that head failed. The second argument Mr. Adams raised was that Carey failed to act fairly and professionally in Mr. Adams' best interests. Now, the court decided this issue by reference to the relevant factual context, and in particular, the contract. Now, the essence of the contract between Carey and Mr. Adams was that Carey's role was execution only, with Mr. Adams being responsible for his own investment decisions. And the court found that you had to read the regulatory requirements in that light. In several places, the contract provided that Carey was not providing advice, and it was not authorised to do so. So in those circumstances, the court determined that the rules could not be construed as imposing an obligation upon Carey to provide advice. To do otherwise would impose an obligation on Carey that exceeded its regulatory authorisation and contradicted the contract. The argument that a duty to act honestly, fairly and professionally in the best interests of the client required Carey the argument that the duty to act honestly, fairly and professionally in the best interest of the client required Carey to refuse to accept high-risk SIPP investments was also firmly rejected. Again, it was the terms of the contract between Mr. Adams and Carey which were key. The contract made clear that it was the client's responsibility to decide what investments should be made, and that in most instances, his instructions should be followed. So the final argument was that CLP and Carey were acting as a joint venture, or that the arrangements were otherwise, that Carey should be held responsible for CLP's actions, and the court found that there was no basis for such a finding. So all arguments raised by Mr. Adams were dismissed. So where does this decision leave the SIPP industry and its insurers? Now, the outcome is obviously hugely encouraging. It suggests that where a SIPP operator has clearly defined its role to be that as acting on an execution-only basis, it is not expected to have undertaken wide due diligence on the underlying investment, as the Berkeley Burke decision had suggested. Also, when the transaction is on an execution-only basis, it is not the SIPP operator, but the investor who must take responsibility for his or her own decision. The judgment should therefore make it more difficult for claimants to succeed against SIPP providers who made it clear that they were operating on an execution-only basis. It is, however, unlikely to mean that all future claims against SIPP providers will fall away or fail, and there's several reasons why I think that's the case. First of all, the judgment is obviously based on the specific facts of Mr. Adams' case. Another claimant's circumstances will be different, and future claimants are likely to try and exploit any areas of difference in the hope of a different outcome. Second, Mr. Adams' claim was fairly narrowly pleaded. He did not, for example, assert a lack of due diligence on Store First, which of course was a significant factor in the Berkeley Burke case. So there is scope for another claimant to argue a different case on similar facts, which could potentially give rise to a different outcome. Third, Store First was a poor but legitimate investment, and it's possible that different considerations and conclusions might be reached where the underlying investment is shown to be a fraud. And indeed, in the Berkeley Burke case, the investment was a fraud and the outcome was the polar opposite. So it's possible that in circumstances where an investment is shown to be a scam, a claimant might be able to show that a SIPP operator who'd undertaken due diligence would have been alerted to that fact, and therefore that they ought to have refused to act on their client's instructions. So fourth, it was significant that Mr. Adams admitted that he would have proceeded with the investment, seemingly regardless of any warnings that Carey might have given. Another claimant may be less honest, or have genuinely acted differently if the SIPP provider had provided a further warning about the high-risk nature of the investment. Fifth, it's far from clear that the judgment will have any significant impact on the FOS's approach to this type of claim. The FOS, of course, determines cases on the basis of what it considers to be just and reasonable, with the law only being one factor that it takes into account. And indeed, the financial press has been reporting the FOS's reaction to the Adams case to be as follows. So, quoting now, "The High Court has already upheld our approach to SIPP complaints in the Berkeley Burke case. We will consider the judgment in the Carey case and continue to take relevant law, including case law, into account when resolving complaints. If customers are unhappy with how their financial provider has handled their complaints, they should come to us and we'll see if we can help." Now, that certainly doesn't provide reassurance that the judgment will lead to any significant change in the FOS's approach. So sixth and finally, it's widely expected that the Adams judgment will be appealed. And if so, there will inevitably be a period of uncertainty whilst that appeal is heard. So in conclusion, before I hand back to Virginia, the decisions in Berkeley Burke and Carey pensions are mixed news for the SIPP industry and its insurers. There are certainly positive aspects, but I doubt the recent judgment will deter claims, particularly to the FOS. Over to you again.
Thanks, Claire. Just to remind you to use the Q&A function if you have any questions after Claire's talk, and before I get started on my section, please do anything that pops into your head and pop it in the Q&A and we'll answer at the end. So future risks and what's on the FCA hit list, as it were. Well, I'm afraid we're not over the worst. We are suffering from the aftermath of pension freedoms being brought in very quickly and with very little planning. On the slide, I've put up what I see as the main problem areas in the sites of the FCA. All of these are defined benefit issues, except for the last one. But it will be some time before the problems fully flush through the system. Some of them are starting to trickle in now, and I would be interested to hear from you on whether you're experiencing any of these too, and any feedback on perhaps other issues. When Christopher Woolard, he's the Chief Executive of Strategy at the FCA, and he was asked what the FCA is doing about DB transfer scams and frauds, he admitted that this is where the rules of the game are catching up with the freedoms. In other words, they're closing the stable door after the horse has already bolted. Consultation paper GC20/1 invites responses for a template by September 2020. It's worth noting that £100 billion has already been drawn down and is continuing. We're a bit late in dealing with it, basically. Claims management companies are not necessarily as alive to PIE or ETV, which is on the slide, as they are to the scams. For those of you who don't know, PIE is making an offer for a higher pension at the start of retirement, yet one that isn't inflation protected later. In the case of PIE and ETV, this isn't just a case of it being a contract between employer and employee. There are advisors involved. it requires a significant amount of sophistication to price the inducements out of the scheme and to make the right offer. It's unlikely to be a sensible option pretty much for anyone unless they have a short life expectancy. The offers have been pitched to look tempting on the face of it. All these sprightly 60-somethings off enjoying their world cruises while they can, still have the health and energy, perhaps not having enough money later on when they need care. But actuaries have done profiling to work out your likely longevity based on sophisticated modelling of your age, your job, your likely health, your postcode. So for the investors, it's basically gambling. And as with all gambling, the odds are heavily stacked in favour of those setting them. The employer is offering this for a reason. In the last pension mis-selling scandal of the 1980s, 90s, we were still dealing with that mis-selling as we approached the turn of the millennium. And I go back to my point on the economy. We've had coronavirus, probably about to have a no-deal Brexit or something similar. An economic downturn will lead to more claims. I'm no economist, but I've read what the Organisation for Economic Cooperation and Development says, the OECD, and it has warned that the UK is likely to be the hardest hit by COVID-19 among major economies. The reason for this is that our GDP is made up largely of the services sector, including financial services, hospitality, tourism, making up about 3/4 of the UK's GDP. Forecasts are inevitably inaccurate because they're crystal ball gazing, and they're a little unreliable, therefore. But the OECD says that the UK economy is likely to slump 11.5% in 2020, or possibly go as low as minus 14% if there's a second wave of the pandemic. Now, we've been speaking for long enough. I conclude by saying that I think a rebalancing of the premium paid by IFAs has been long overdue. For the poor IFA, it's never been more important to have a clean claims record. There are ways of getting good deals, as you could see from the poll, which was really interesting. But going forward, unfortunately, I see no reason for the insurance market to soften up. I think it might even harden further. So without, Claire and I will now take any questions in the Q&A section. So please write them in there if you have any. Claire, have you been looking in there while I've been talking? Got anything? You're on mute.
Yeah, sorry, there was feedback and I then forgot to mute myself. So first question was, do I think that the Berkeley Burke decision would have been any different if it had just been decided by the court rather than the FOS? Well, inevitably that's difficult to say, but of course the court reaches its decisions on the basis of the law, whereas the FOS looks at what's fair and reasonable, so takes a much more subjective view. Possibly significant that in Carey, the court found that there was no general duty to undertake due diligence on the underlying investment in the SIP, as the FOS had found the opposite. So that could point to that a different conclusion would have been reached by the court. But where the two cases are different is that the Berkeley Burke investment was a scam. And what's not clear to me is whether, well, I think the FOS did find that Berkeley Burke should have been alerted to that, but whether a court would have reached the same conclusion, obviously we don't know. And but I suppose that's the risk, that Berkeley Burke potentially should have appreciated that the investment was a scam, and if so, then potentially a court might have found that it shouldn't have accepted the SIP investment. But as always, you never know what might have been had circumstances been different.
Okay. Any other questions? There's one I feel able to answer. Do I think there will be another full pension review in light of the recent RFIs on DB work? Yes, I do. Unfortunately, I think there are still too many defined benefit schemes around for the risk of members making incorrect or ill-informed decisions. And yes, I think it's quite likely that that might happen. obviously may not happen yet, but yes, I can see that happening in the next couple of years, yes. Any more questions? Feedback? Well, I think a recording of our talk will be available. Any questions on discrete issues we may respond to in private by email. We've had a couple that perhaps on the appeal of the decision, and another one on in-specie transfers. But I could answer that one. Are you seeing many more in-specie transfers? It doesn't really arise in the context of occupational defined benefits or defined contribution schemes. It refers to transfers that are inside a small self-administered pension scheme as SAS or a SIP. And we, as a firm, we advise corporations rather than individuals. We've seen that, and I haven't seen a huge number of claims involving that. So, anyone got any other comments or questions? If not, I think we will say goodbye. Thank you very much for joining us today.
Thank you.
Thank you.